Chapter 4 of the Consequences of Breach of Contract, Section 73 to 75. The principle of assignment of damage for breach is given is Harley versus Baxendale. A. Having contract with B to supply B 100 ton of iron at rupees 100. A ton to deliver at the time contract with C for the purchase of 1000 ton of iron at rupees 80 a ton, telling C that he is required so far the purpose of performing the contract in B. C failed to perform. A will entitled to compensation for the loss of the profit along any damages which might have been paid to B on account of breach. If the compensation to be paid on the breach of contract it is the genuine pre-estimate of the prospective damage, it is known as liquidated damage. The determining the amount of any compensation awarded under this section 21 of a specific relief act, court shall be guided by the principle specified in section of dash of the Indian Contract Act, section 73. Which one of the following is not relevant is in determining the quantum of damage under section 73 of Indian Contract Act? Manners. A. Contract to sell and deliver 500 balls of cotton to B. On a fixed date, A knows nothing on B mode of conducting his business. A break his promise and B having no cotton obliged to close his mill. In the responsible, A is the responsible for loss caused by B by the closing mill. No. Point out the incorrect statement. C is incorrect. Which is correct are: a party who rightfully rescind the contract is entitled to compensation for his damage. When a person give any bond for the performance of any act in which public is interested, he shall liable upon its breach to pay the whole sum mentioned therein. The rule of compensation for loss of damage caused due to breach of the contract contained in section 73 of the Contract Act does not apply to a void contract. Damage allowed under section 73 of Indian Contract Act are compensatory damage. Which one of the following section of the Indian Contract Act 1872 impose a person who suffered for damage a duty of migrant and loss consequent upon the breach of contract? Section 73. A agreed to sell B a certain quantity of guinea bag delivered from future date. Before the due date, B assigned beneficial interest in the contract to C. A commit the breach of contract. Which one of the following is correct? C is entitled to sue for damage and for not for delivering any guinea bag. X agreed to supply 100 ton of iron at rupees 100 per ton and Y to deliver not later than the 31 2002. X also entered into contract with A for purchase of 1000 ton of iron at rupees 80 per ton, telling A clearly that iron is needed before 31 2002 for supply to the Y fulfill the contract of Y. A failed to supply the iron to X, who turn failed to the supply the same of Y. In the action by X against A, X can recover the damage for the loss of the profit he would have earned at the time of supply to Y. Also the damage for the X to paid Y on the account of the breach of contract. Which one of the following cases is not related to the damage of breach of contract? State of Rajasthan versus Novtel store is not related. Which one is related is Hadley versus Baxendale, Madras Railway Company versus Govinda Rao, Dominion of India versus Ali India Reporter Limited. Section 73 of Indian Contract Act incorporated rule from which one of the following cases? Handley versus Baxendale. What kind of damage can be granted under Indian Contract Act 1872? Compensatory damage. The principle contained in the Section 73 of Indian Contract Act is based on Handley versus Baxendale. The remedy for the breach of contract are compulsory damage. Handley versus Baxendale deals with remoteness of damage. Under Section 73 of Indian Contract Act, special damage can be claimed if the party breaking the contract is made known to be special circumstances at time of the contract. When there is a breach of contract, special damage are awarded only when there is notice of the likely special loss. Breach of contract may actual and anticipatory. Handley versus Baxendale is a leading case on remoteness of damage. Under law of contract, the primary and the law of damage is to place the party who sustained the loss in the same position as if contract has been performed. V places an order with S for support of 20 swing machine. S could not supply this in time. V loses the profitable contract due to this fact that was not communicated to S, and the claim of his loss of the profit from S, but V does not succeed the nature of the damage. Special. Consider the following statement with regard to the consequences of breach of contract. In the case of breach of contract, the party who suffered is entitled to receive compensation for any loss or damage caused by him thereby. When the parties knew when they were made to the contract, they are likely to be result of the breach of it. Section 73 of the Act is based on the which judicial pronouncement? Hadley versus Baxendale. Where the rate of interest is prescribed in the case of breach too high, the court can interfere on the satisfaction that stipulation is by way of penalty. The law relating to the payment of damage is based on the leading case Handley versus Baxendale. Handley versus Baxendale is a case on damage for the breach of contract. A give a recognized binding him in the penalty of 500 to appear in the court of certain day. He forfeit his recognition. He is liable for to pay the whole penalty. Section 74 of Indian Contract Act 1872 applies to the case where agreed party is seeking to recover the fixed amount on the breach of contract. Under Section 74 of Indian Contract Act 1872, the court cannot award damage A more than amount is stated in the contract. In the case of breach of contract, which one of the following remedies are available to the aggrieved party? Suit for rescission, suit for damage, suit for specific performance. A stipulation for increased interest for the date of default is known as penalty. No one is allowed to enrich himself on the expenses of other. The principle is known as quasi contract. When the damage cannot be assayed, the party may be awarded by the court exemplary damage. while the determination of damage of the breach of contract, which one of the following is taken into account? Means or remedying the invoices caused by the non-performance. When the contract has been broken, the party who suffered when such breach is entitled to receive from party who has broken the contract compensatory damage. In liquidated damage are essentially genuine covenant pre-estimated damage. Which one of the following is not a remedy of breach of contract? Fine. Accord and satisfaction are terms related to breach of contract. If the compensation is to be paid on the breach of contract, the genuine pre-estimated of the prospective of damage, it is known as liquidated damage. While determining the damage, which one of the following is taken into account? Inconvenience caused by non-performance. The duty to mitigate damages on the part of injured party arises in the case of breach at the time fixed for the performance of contract in the case of anticipatory breach. A person who sues for damage under law of contract has a duty to mitigate the loss consequently upon the breach of contract. Which one of the following is a correct sequence in the claim of damage of the breach of contract? Contract breach damage. The basic action under the remedy of quantum merit is restitution. A contract does not stand discharge by a mere delay in performance. The loss and the damage arises from the breach of contract is to ascertain at the date of the breach of contract. A person who sues for damage under the law of contract has a duty to mitigate the loss consequently upon the breach of contract. What is the remedy available for the breach of contract in the case where person enjoy the benefit of non-gratuitous act although there is the existence of no express agreement between the party? Suit for quantum merit. If the sum is fixed, represent a genuine pre-estimated of the probable damage that are likely to the result from breach of contract, it is considered as liquidated damage. X hand over the expenses of sari for cleaning the dry cleaner who losses. The same. X claim the total value of sari. Dry cleaner refer to the clause printed on the contract receipt which stated that dry cleaner can be held liable for rupees 50 or 10% of the original value of cloth only whichever less. Which one of the following preposition hold a good explanation of the correct position of law on that point? The court will be award reasonable damage ignoring the clause as unreasonable. Consider the following objective the law relating to the contract. Put the party who sustain or loses in the same position if the contract has been performed. The case of Hadley versus Vixendale is related to damage for the breach of contract. A party who does not suffer any loss in the case of contract is entitled to nominal damage. The loss or damage arising of the breach of contract has been ascertained at the date of the breach of contract. Which one of the following does not amount to the breach of contract? None of the above. Which one amount to the breach of contract? Non-performance of obligation, performance in the manner not according to the contract, performance in the time not according with the contract. The primary aim of the law of contract of damage is to place the party who sustain the loss in the same position as the contract has been performed.